To preface this all by saying that I'm by no means an expert in probate or trusts, but I've seen enough stuff during my career that I think I can shed some light at least on some of this. So, does everybody know what a probate is or have a general idea of that a little bit? So probate comes into play traditionally, and there could be some caveats to that, but for purposes of the class, probate comes into play when somebody has passed away and didn't have an actual trust in place. And this is why I think it's so crucial for people to have a trust, because that way the decedent's wishes are already clearly outlined in their trust, and they've identified how they want everything to be handled. Who gets the money, if they can sell the property, whatever, right? Like in my particular trust, I told my kids I don't want them to sell my condo. I don't want them to sell either one of my places. I want them to keep them, rent them out, do something other than let them go, because they're an appreciating asset. And I don't believe in selling an appreciating asset unless you need it to further, your next move. So anyway, so probate comes into play when somebody, didn't have a trust. A will simply isn't enough when it comes to real estate. That's why a trust is so crucial. So typically what happens with probate is that it's a court hearing, and you have a judge that presides over the hearing, over the actual proceedings in terms of how to distribute the whatever property and monies are left after the person has died and has not identified what they want to do, right? So the most common question I get is someone will say, hey, I've got, a listing coming up, and they say it's in probate. So here's the things that you need to know about probate. Does it require court confirmation or does it not? There are certain portions where it doesn't require court confirmation, and whoever is the heir can actually list and sell the property, and they don't need to get approval. A lot of times, though, unfortunately, they do need to get court approval. So you aren't expected to know exactly what that's going to be, but typically there's an attorney or somebody who's involved who will know whether it is requiring court confirmation or not. You may have seen stuff on the MLS where the listing agent says, such and such probate sale, no court confirmation required. That's the best case scenario. That's what you actually want. If they don't require full-on court approval, it's wonderful. It still can be a slower process. But if something requires the actual approval, then what they'll do is the court will be looking for basically the highest bid, trying to maximize what they can out of that potential proceeding, or the potential proceeds. So if you come across one, if something's coming up, then just get in touch with whoever is handling the probate, and they'll let you know what kind it is. I have only had to deal with a probate one time. It was a very long time ago. It did not require court confirmation. The transaction went really smooth. I did have one where a client wrote an offer, but there was going to require court confirmation, and they actually had multiple bids, and they took the bids to the court. Mine wasn't the highest offer, so we didn't end up getting it. But the way that it played out is they had to go to court and get approval. So if you know anything about the court system, you know that it's not really an expeditious program, right? They don't exactly move quickly. They don't exactly give you 15 days and boom, you're done. You've got approval. It's just not how it works. So I'm not going to go through every type of this, but when you've got something that's in probate, there's going to be a conservatorship, guardianship, receivership. There's going to be one of those options, right? And then of course it's going to be, if they need to get the court confirmation, it's going to be in here, like this would be 3B, that would require court confirmation and a hearing date. And so basically what happens is the listing agent has a certain amount of time to present the information to the court and give notice to that, because the court docket can be pretty backed up. They say generally 60 days. And they're basically petitioning the court to allow the sale of the property. Does that make sense? Okay. So again, if you come across that situation, it's important to find out what you're dealing with so that you can prepare your client. Like I said, I didn't get my offer accepted on that one where it had to have court confirmation. And so in terms of dealing with your client, they just have to know that it may not move super quickly. But also sometimes they will require, before even the court can, if they decide, require that a buyer's contingencies be removed prior to getting the prior to allowing the sale. So, which always makes me a little bit nervous. But you know, really, you couldn't actually. I don't really see how you can protect your buyer without having contingencies in place. But if this listing agent knows what they're doing, they're going to provide as much upfront as they possibly can so that they can present a clean offer to the court to get acceptance. Questions? Dawn. You got to unmute yourself. Here, I'll unmute
there.
you.
Sorry.
Yeah.
Okay, so I have run into this situation because I had a buyer this week that I took out. The address is 430 West 9th Street in Pittsburgh. But I want to read to you what it says. It's a probate, and they said cash only, all cash offers only, offers subject to court confirmation. But also here in the confidential remarks, it says, there's a lot in there, but it says only one offer will be selected by the seller to submit for court's approval.
Yep.
Any buyers may show up on a scheduled court date to submit an offer. No contingencies at that time.
Right.
So how do we find out about a court date?
So yeah, and I'm sorry, I should have mentioned that because that can be, they encourage, and it actually says in this form, they encourage the buyer to actually show up for that. It says right in here, broker strongly recommends that buyer personally appear at the court confirmation to protect the buyer's position in the event of overbidding. So again, I've never actually seen anyone do that, but it is, you know, at the buyer's discretion to do that. The reason why they're doing cash is because they don't want any contingencies. I guarantee that that's why that is, right? And they're going to have to actually demonstrate to the court too that when they walk forward with only one offer, they're going to have to be able to explain that they received 7 and this was the highest and best, right? So, but yeah, like they actually allow an opportunity. A buyer totally has within their rights to show up in court and make sure that their offer was presented, especially if they think that there's, especially.
Is that referring to whoever made the offer? Is that what that was in reference to, or is that?
Yeah. Just mute yourself.
Sorry.
Or someone was unmuted. Yeah. So basically they recommend that the buyer do that just to make sure that they were, you know, that their offer was, you know, presented. I don't see a scenario upon which somebody wouldn't, if they're trying to get court confirmation, present the highest and best offer. I mean, that doesn't make any sense. Why would you not do that? I mean, you want to make sure that the court's going to approve it. So you would, of course, be trying to pick the highest and best offer. So anyway.
How would we find out about that court date? Is that something given to you if your offer was selected?
The listing agent would be able to tell you. Yeah.
And if you can get a hold of them.
Well, yes, that is true. But the listing agent, they full on know when the court date is because they have to go and present the offer. They know when they'll be able to tell you for sure. So anyways, you know, like in an ideal situation, clearly in an ideal situation, you want one that does not require court confirmation. There's also, if you take a probate listing, there's also an addendum to the actual listing agreement that you can incorporate or that you will incorporate, right? And it just basically says what type of probate it's going to be, if it requires court confirmation, et cetera. So whoever's handling the estate, whether it's an attorney or an attorney in fact, whatever the case may be, they're going to know, again, if it's court confirmation or not. So they'll be able to direct you. Make sense?
Yes. Thank you so much.
Yeah, no problem at all. The other thing that I wanted to talk about is there's a trust advisory. So if you have a property that's being sold in a trust, and this can be whether, I mean, like if I decided to sell one of my properties, both my properties are in a trust, I could sell that through the trust, even though I'm living. It doesn't matter at all. But if someone's deceased, they can absolutely sell the property in a trust. But here's what you need to know. The first thing I always recommend to somebody is if they're going to be dealing with a property in a trust that's going to be sold, basically the beneficiary, whoever's been determined that they have the authoritative capacity to actually sell the property is going to be the one that's going to be in charge. So what's going to have to happen, the first thing I always recommend is if you're dealing with a property in a trust, let your client know that the title company, as a part of insurability and verification of the authoritative capacity for somebody to sell the property, they're going to need the trust at the title company. The title company will review the trust and make sure that the appropriate party is legitimately able to sell the property. So you got to prepare your clients like, hey, title's going to want a copy of the trust. I always tell my client, look, I don't need it. I don't need to look at it. It's personal, it's private, it's whatever. If you don't want to share with me, no big deal. You can send it directly to the title company, but they are going to need that. If it's a situation where like there's a very recent death, and I don't know what the title company timeline is on this at this point, but if they may require that they do an affidavit of death, which would mean that they would have to provide an original death certificate, and they would do an affidavit of death, and they would record that alongside the actual sale of the property. So your first call to the title company, find out if there's any weird or any wonky thing. I always have them do a pre-escrow so I know what I'm dealing with. Neil first and then Don. Neil, go ahead.
Yeah, sorry. There was a statement about overbidding. So is that if there's multiple offers are being taken to the court and basically they can't choose and then they just basically open it up to bid?
Yeah, what they'll do is they'll say it's open to bidding, and this is, I think, where the part comes in for a buyer to go in there. And I can't remember what the threshold is, $500 or something, like over, like the court can kind of like escalate the offers, so to speak.
Okay, all right.
But again, it's all a negotiation. Buyer doesn't have to agree. So,
yeah, I get that. Yeah. Thanks.
Yeah, everything's negotiation. Don?
No, I still had it up from before. Sorry.
Oh, okay. No worries. So here's the other thing. Like sometimes people think that if the property's in a trust, that like they have no disclosure. They just think, well, the property's in the trust. I don't live in the property, whatever. I don't have to disclose anything. Wrong. They're still required to disclose anything that they would potentially know. They're obligated, to tell that. Like for instance, if if there's a death on the property, it was natural causes, whatever, they just have to disclose that. No big deal. But that's the same thing with any sort of disclosure. Whether they live there or not, if they know there's death on the property, they have to disclose that, right? They are not exempt from the natural hazard disclosure report. They have to provide that to the buyer. Smoke detectors have to be in place. The water heater has to be, properly strapped. There's certain things that they're not exempt from. The lead-based paint disclosure, if the property's before 1978, the actual carbon monoxide devices, those have to be in the property. The water conserving plumbing fixtures, they're not exempt from that, but I don't really see anyone enforcing that. So that's been in place for quite some time. But I certainly don't see people running out to properties to verify that the water conserving plumbing fixtures are in place. Yeah, Neil.
I've been to a couple where properties where power's turned off. Is that something they have to have on, or you just have to...
Absolutely. And so this was a really common thing in my days in foreclosure. In the REO days, it was I'm going to be honest with you, it was a total pain in the ass, because as an REO listing agent, I'm dealing directly with an asset management company or the bank, and they never wanted to have the property. They never wanted to have water and stuff on the property because they don't want to pay for it. But it was a requirement. The buyer cannot do their due diligence without water and power. They can't.
Right, it's part of the property investigation.
Yeah. So as a listing agent for those, at that time I had a full-time assistant just to assist with this kind of stuff. But I would have to turn on the utilities in my name and then get reimbursed later, because I had to deliver a property, with the ability for somebody to do their investigations. So the same thing in a probate or in a trust, it doesn't matter. Like they still have to provide access so that the buyer can do their due diligence. And then, also in the trust, they're not exempt from tax withholding. If it wasn't the decedent's, primary residence, if it was an investment property, whatever, there's going to be tax ramifications, and they're not exempt from that. The actual trust, the estate has to settle all that. Megan's Law, all of the general things that they are requiring. So it would be difficult it may not be easy for someone to do the transfer disclosure statement if they aren't really, really privy to what's going on in the property. I've seen something where somebody hadn't been to the property in a really, really, really long time. They didn't know much about it. And so it's difficult for someone to do a transfer disclosure statement. What I would still recommend is that, and I had one where I had a power of attorney, an attorney in fact for the property. I just had her fill out the TDS to the best of her ability with notations that she hadn't lived in the property in 30 years, that the mom had been there. She'd been over to visit, but she didn't really know the ins and outs of the property and what was working and wasn't working. And so we just tried to navigate that best we could to satisfy the disclosure. So, anything else on that? No. Okay. The other thing that I wanted to mention is, so there's a trust signature addendum, which, come on, why isn't it pulling up? Huh. Oh, that's why. I was like, I remember there being a trust addendum for the signatures. That's because it's been replaced with the representative capacity signature disclosure. Okay, let me pull that one up because I have that one ready. Where is it? Okay. So you may have seen this. There's one for seller, one for buyer. So in my case, somewhat recently, I had a power of attorney. Essentially what happened was the mom was entering into advanced stages of dementia. The daughter was able to obtain power of attorney, and she basically, like, begrudgingly, because she didn't want to have to sell it, but she basically had to sell her mom's home to further mom's care in a care facility. So she got power of attorney. So she provided, the first thing I asked, she said, hey, I've got power of attorney. I'm going to need to sell my mom's home. I said, great. I need a copy of the power of attorney. Cool. She sends it to me. First, she said, how come? I said, well, I got to talk to the title company and I got to make sure that all the I's are dotted and the T's are crossed with the power of attorney so that it is very clear that you have the authoritative capacity to sell the home. I sent the power of attorney to the title company and there ended up being a discrepancy on when the actual power of attorney was signed and when it was notarized. Well, when she got this done, she didn't consult me first and she just went to a UPS store. And so at the UPS store, they did the notary. What we think happened is that maybe the notary messed up on when the actual date was of the signing. She tried to go back and get in touch with UPS store, see if that notary was still there, see if they could get it corrected, see if they could compare in their ledger where they have the signatures and the fingerprints. Anyways, what title ended up asking to do instead is that we do a brand new power of attorney, which meant that the actual, that the mom had to sign again. And the title company was awesome. Chicago Title, I love them for this. Candace is super awesome. We were able to basically meet the seller, or, the mom on a day where she was full, aware of what was going on and was able to sign. And so they redid the power of attorney. So basically I had to do the representative capacity disclosure, and I basically had her sign her name, Stephanie Fable, as attorney in fact on everything. So that's how we handled that. So you would need to clearly identify, the capacity in which your person is signing. So there's one for a buyer, and then there's one actually for a seller as well. Yes, Christina. Unmute yourself.
Oh, sorry about that. I actually took a listing where the mom is really going in and out of dementia, and the daughter-in-law had a POA. The POA didn't really do much for them because the mom, she was able to speak to a buyer or a friend that took over the property. So the friend just bought the house straight from the mom.
I remember this one.
Without telling the daughter-in-law who had a POA. So it was a mess. They went to, right now it's being investigated for like elder abuse because the buyer just went, so it's really a mess. The POA really doesn't do much, and because if the mom is still able to take care of her affairs. So we just need to be aware of that. I didn't know it until that happened.
Exactly. So, and that's a really great point. And I remember that case with you. the power of attorney is only so good as it can be executed. And if the mom was well enough and did, you know, and it, Christina and I talked about that a lot when it was going down, and it's really unfortunate because I think it's probably a very clear-cut case of elder abuse and just taking advantage. And, you know, I don't know, that's going to be really messy trying to determine, you know, whether or not she was really capable of making that decision and, you know, pretty much nixing the power of attorney. The other, so again, so on this form, and like I said, there's a seller and there's a buyer version on here too. You just have to decide how it's being handled, if it's in a trust, if it's an entity, like right now. So my REO listings, all of them are going to be in either an LLC or an S Corp. I don't really deal with partnerships. The one that I deal with most often is an LLC. So I have to have the name, like it's something stupid. This one I have right now, Igloo Series 5 Trust, Security National Association, It's like this super long thing that I had to use 2 lines on the contract and the listing agreement to put the whole entity on there. But I had to get a copy of the grant deed, where the asset management company took title to the property. And so I had to provide those documents to the title company, and they have to verify that those documents are going to be sufficient to give them the authoritative capacity to sell the property. So you can use this in a lot of different ways. There's all kinds of stuff. Could be the trust, could be a corporation, could be the power of attorney. And it's entirely possible for somebody to be purchasing a property in their own trust, right? People do that all the time. They buy a property within the trust. Most people buy the property on their own and put it in the trust afterwards. But I see it where people are in the trust already and they buy. It's totally fine. They can do that. Any questions on that? Sure. Go ahead, Christina.
Can you elaborate about that? People can buy the property that's already in a trust. Who's buying the property in a trust? Like let's say my property is in a trust. My daughter can buy it while it's there, or how does that work?
No, what I'm meaning is that somebody may already have a trust in place, and they can actually buy a home in the name of their trust. Yeah. Make sense? Yeah. I don't see it super often, because most often I've seen it where it's like an executor was doing that. I've seen it a handful of times where a buyer had a trust and they were very specific about buying that particular property in a trust. But the most common is someone buys it as an individual and then puts it in the trust afterwards. That's the most common. And like I said, if there's ever any question, title is a terrific resource, because they know exactly what's going to be required in order to be able to transfer property. That's, you know what I mean? They're really great that way. Like I said, I don't mess around. I go to them first. Like, what are we going to need? You know, right up front, because there are some there's some quirky situations that come about. And if it hadn't been for me immediately going to the title company with that power of attorney, I could have been way down the road and had a lot of problems. I would have gotten into contract. I would have sent the contract over to the title company to be in sale. They would have said, no way, this isn't going to fly. I mean, it would have been a nightmare. So definitely hit up the title company first. Save yourself a lot of heartache on the back end if you can. That would be my recommendation. The other I mentioned, so they could do it in trust, an entity, a power of attorney, and or in an estate. I've never witnessed someone buying something in an estate with a guardianship with the court. I haven't seen that before at all, so I really can't speak to that one. Clearly it exists, but it's nothing I've ever been in the business since 2002, and I've never witnessed that. But you know, it's out there clearly. That's why the forum is here. Any other questions? I figured this class was going to be pretty short and sweet. I just wanted to kind of bring these ones up because I don't think that you deal with it very much, but it's something that you should certainly be aware of, because you're going to come across something in your journeys selling real estate. You're going to come across this stuff at some point. And always too, you know, if you've got a situation you're not sure about, call me, and I'm happy to share my experience, you know, and what I would recommend too.
So it's interesting you bring this up because that offer I wrote, remember I was talking to you about they wanted the 60 days.
Yep.
Right, for the 1031 exchange.
Yep.
This was in there. So for the seller side.
Yep, exactly.
So in that case, what you're looking for is to see if they already have, like if they had a title report up front saying that, how does the title company, I guess, verify they just have lawyers look at it or they look at the power of attorney?
So
Yeah.
what happens is that they're underwriter. So the way that title and escrow works, escrow is obviously, they're obviously the front end with, handling all the documents, correct? But title, it's underwritten just like a loan is, right? So they have an underwriter. So in order to be able to ensure an accurate chain of title, which is a 2-year roll, they want to make sure that they have all of the documents in place that establish that, yes, that person has the authority to sell.
Okay.
So that's why the power of attorney in this particular case, it looked kind of janky. They did it on their own. They went through a UPS store. Title's like, yeah, that's not going to fly. And the reason why they said that's not going to fly is because there was a discrepancy. But the other thing is they are not going to insure that title unless they're totally sure that it's the right parties. And that's why they always want to look at the documents. So anytime a property is in a trust, they're going to say, we need a copy of the trust documents. Anytime. And in the trust is everything, right? That's why I always tell my clients, like, you don't have to show me the trust. I don't need to know who the beneficiaries are or anything like that. I don't need to know that, but the title company needs to know. So, yeah. So I usually prepare my clients like, hey, it's not meant as an invasion of privacy. It's just validating who has the authority to sell. Same thing like with a refinance too. They would want to make sure that if it's in a trust that it's properly done. Any other questions? No? Short and sweet. Hopefully you find that helpful. I think it's always a good idea to kind of be looking at forms you're not used to and just getting just a general overview so that if it comes up, you don't have to say to your client, I have no fucking idea and I'll find out later. It's always good to know something.
Oh, you can say that?
I know, right?
What I usually do when I take a listing or I'm in a listing appointment is if one person is only present, there's no husband and wife, both of them are not there. I usually ask, did somebody die, or is there 2 people that own the property? Is the property in a trust or some? I usually ask that right up front so I can ask the proper document.
Yeah. Okay. So that's actually a really great point. Thanks for bringing that up. Okay. So if you, and this happened to me a couple years ago, and this seller was a total nightmare. So I got this listing. First thing I did was pull up, public records, and I'm like, there's 2 people on title. So he tells me, he goes, well, that's my ex-wife, and an attorney's going to handle it. He's going to get her off title. I said, whoa, no can do. No can do. He's like, what do you mean no can do? I said, she's on title. I need her permission as well. Now, one seller can sign the listing agreement. That's fine. That's permissible. They can sign the listing agreement, but title isn't going to allow them to sell the property unless both parties sign off, right? So in this particular case, like right up front, I had done the homework. I'm like, hey, who's such and such on title? Oh, that's my ex-wife. She's going to sign off. I said, nope, not going to work. I said, she's going to need to sign a quitclaim deed to get off the property. So extortion, I guess they had a really horrible marriage. At first I thought it was her, then I realized it was him, definitely him. He fought me on it. And I said, look, dude, we're not going to be able to do anything. I don't even want to go on market until we get this addressed. Because what I don't want to do is go on market. At the time we were getting multiple offer situation too. I didn't want to get multiple offers and then go back and like, look, I can't transfer title because we can't get a hold of this other person or she won't sign off. Well, in this particular case, she was like, yeah, I'll sign off. I want 10 grand. So I mean, you got to do what you got to do. I was like, yeah, but the thing is that you have to do whatever it takes to get her off title or you don't get to sell the property. So the guy, it was just a horrible nightmare. He was a disaster. But he's, I don't have the money. And she's not going to sign off. And then he kept saying, well, I don't want to give her the money and she's not going to sign. I'm like, listen, dumbass, we're not going to give her the money and not have her sign. This is pretty straightforward. We're going to do it at the title company. A check is going to be prepared. She's going to sign. They're going to exchange. That's how it's going to work. He was just couldn't, wrap his head around it. And it took a while, and it was some back and forth negotiation. And I'll tell you what, Chicago Title, Candace Chaparra came through for me again because she basically got in touch with this gal and made it happen. But it was not pretty. It was a process. But if I hadn't done that until later down the road, I would have lost the buyer. It's just not, I mean, you just got to be prepared for that kind of stuff. So if you ever see something that is two people on title, if they, like Christina said, she asks if they're deceased. If they're deceased and the property is like, husband and wife with rights of survivorship or community property or whatever, then it's automatically going to transfer, but then they'll need an affidavit of death to confirm that the person passed away and that the receiving party of the other half of the estate or in that particular interest in that particular property will be transferred. So lots of little nuances that that come up. So any other questions? No? Okay, great. Thanks you guys for jumping on. I always appreciate anyone that's attending my classes, and it's good, review for me as well, because, stuff just comes up and we're always learning and evolving. I certainly don't know everything, but every day something new comes up. So it's always good stuff.
Good stuff.
I love about this business. What's that?
I said it was good stuff. Thank you.
Oh, you're welcome. Very welcome. Okay, guys, I hope you have a great rest of the day. Get out there and kill it.
Thanks,
Bye.
Sonia.
Bye, guys.
Bye.
Later. Bye.